All right, let's just get right into it. Welcome back to The Explainer, where we take complex documents and turn them into clear stories so you can really grasp how these systems work. Today, we're diving headfirst into the incredibly fascinating and, honestly, surprisingly strict world of administrative property law. It's a realm where the fine print literally dictates reality, and we've got a fantastic real-world example to unpack today.
So, here is our roadmap for today's Explainer. First, we'll look at the core of the Power Ranch dispute. Second, we'll tackle defining the jurisdiction. Third, we have a tale of two entities. And finally, we'll break down the final ruling.
Okay, Section 1. The Power Ranch dispute, setting the legal stage. We're going to look directly at an actual 2019 legal order to see exactly how planned communities operate under the microscope of the law.
When disputes blow up between individual homeowners and their planned communities in Arizona, they don't usually head straight to some dramatic, televised courtroom trial. Nope, they often end up right here, at the Arizona Office of Administrative Hearings. This is the formal, bureaucratic arena specifically designed to sort out these exact kinds of community grievances.
Which brings us to a super relatable question. Can your HOA actually be held responsible for the golf course? This is the burning question that the petitioner, Pius J. Lacher, tried to answer when he filed his official dispute. I mean, imagine living in a gorgeous golf course community. It is incredibly easy to just assume everything you see is managed under one big organizational umbrella, right? Well, let's see how the law views that assumption. Let's crack open the case file. The petitioner is Pius J. Lacher, and the respondent is the Trilogy at Power Ranch Community Association. The case number is 19F-H1919055-REL. And the immediate conflict, the current status we're dissecting today, is a pending motion to dismiss. Now remember, we are staying completely neutral here. We aren't picking sides on who is morally right or wrong, but rather looking objectively at the precise legal mechanics of how the state handled this dispute.
Moving on to Section 2, defining the jurisdiction, the rules of the arena. Before a judge can even look at the evidence to decide who's right or wrong, they have to consult the rule book to see if they even have the power, the jurisdiction, to decide the case at all. It's like a referee making sure they're actually standing on a basketball court before calling a technical foul.
Let's look at the exact wording from the Arizona statute. It states, for a dispute between an owner and a planned community association, the owner or association may petition the department for a hearing concerning violations of planned community documents. Did you catch that? The absolutely crucial phrase there is planned community documents. The law is incredibly specific about the types of paperwork that can actually be disputed in this venue.
And there is a very strict statutory sequence you have to follow. Step 1, file a petition concerning those specific community document violations. Step 2, pay the filing fee to the commissioner. And Step 3, that fee is deposited into a highly specific fund, the Planned Community Hearing Office Fund. You literally have to follow these steps perfectly to trigger the jurisdiction of this legal body. It's basically a rigid administrative lock, and you need the exact right key to open it.
All right, Section 3, a tale of two entities, the crucial mistake. Let's get into the twist of the case, because this is where we analyze the specific documents Mr. Lacher actually used. This is exactly where things unravel.
Now, this is where it gets super interesting. Look at the entities involved. We have the respondent that Lacher sued, Trilogy at Power Ranch Community Association, the HOA. But then, we have a completely separate entity, the Trilogy Golf Club at Power Ranch. They might share a similar name, and yeah, they share the exact same physical geography, but legally, the golf course and the association are two entirely distinct legal entities.
And right here is the critical error. In his petition, Lacher alleged a violation of CC&R 6.3.2. But actually, scratch that. That provision belongs to the golf course declaration, which was accorded in 2006. He completely failed to allege that the HOA violated any provision of their own specific association declaration from back in 1999. So he brought the lawsuit against the Homeowners Association, but he essentially cited the rulebook of the golf course.
Lacher tried to argue that their interconnected history meant the golf course document should count as a planned community document, which would give the office jurisdiction. But the judge's logic cuts right through that. She noted, while the association may have certain obligations under the golf course declaration, that does not bring the failure to meet that obligation into the jurisdiction of the Office of Administrative Hearings. In simple terms, a shared history does absolutely not override strict administrative boundaries.
Which brings us to our final section, Section 4, the final ruling. The verdict is delivered. Let's look at the ultimate conclusion handed down by Administrative Law Judge Tammy L. Eigen here.
The outcome is blunt, clear, and absolute. It is ordered dismissing the petition, dated September 20, 2019. The big takeaway here is that in these highly technical legal disputes, citing the wrong rulebook for the wrong entity doesn't just give you a weak argument. No, it results in an outright dismissal before the actual facts of your grievance are even debated.
But, there's actually a real measure of fairness in this ruling. The judge explicitly wrote, "This is not to say that petitioner may not have the right to seek resolution of this matter in another venue, but only that the Office of Administrative Hearings does not have the statutory authority." That is a vital distinction. Lacher might still have a fantastic, winnable case regarding the golf course. He just walked into the wrong arena.
An administrative dismissal like this definitely echoes through the system. The officials notified include Judy Lowe, the Commissioner of the AZ Department of Real Estate, the petitioner himself, and the respondent's attorney, Josh Bolin. They're all officially bound by this mandate with the statutory right to request a rehearing within 30 days, of course.
So let's wrap this up with a question for you. Do you actually know what is strictly governed inside your own HOA's CC&Rs? Because as we've seen today, it's way too easy to blur the lines between your community association and the surrounding amenities, like a golf course, a clubhouse, or a shared road. I highly encourage you to pull up your own governing documents. Know your boundaries, so you don't make the same costly, time-consuming mistake of bringing the right complaint to the wrong arena. Thanks for joining me for this explainer today, and keep exploring.